Okay, good morning, everyone. I'd like to call our April 3rd Environmental Control Board meeting to order. I'll ask our parliamentarian to do a roll call to verify quorum.
Good morning. Commissioner Asim Rahman.
Present.
Shamanda Graham.
Present.
Jose Marquez on behalf of Joseph Gregory.
Present.
Elizabeth Nauer. Present. Madeline Ligori.
Present.
Russell Pecunis. Arminder Palarana.
Present.
Matthew Schneid.
Present.
Matthew Smith.
Here.
Douglas Swan.
Present.
Lisa Urban.
Present.
Jared Whittington.
Present.
We currently have quorum 11 out of 12.
Thank you very much. We will move on to the minutes of the February 6th meeting. You've received copies of both the February 6th meeting minutes as well as the updated corrected version of the December 5th, 2024 meeting minutes. Are there any corrections or questions regarding the February 6th, 2025 minutes? No. Can I ask for a motion and a second to adopt the minutes? See a motion. See a second. Matthew, do you need a minute? You're still reading?
No, I'm just flipping through.
Okay, good. All right.
I'm just getting to the next
And
page.
we haven't gotten to vote yet. Okay, with the motion, we'll call for a vote.
Are there any objections to the motion adopting the minutes of the February 6, 2025 ECB meeting? And there was one abstention.
Any abstentions?
No.
So one abstention from the fire department, one abstention from Douglas Swan.
Okay. Seeing no objections and hearing none, the motion is approved.
Okay, thank you very much. All right, we'll now turn it over to our general counsel, Frank Eng, to present on the final rule regarding the water penalty schedule.
Thank you. Good morning, Chair. Good morning, board members. On December 5th, 2024, this board voted to approve a proposed rule to amend 48 RCNY 3-126, the water penalty schedule. The amendment would revoke the schedule to delegate to the DEP Commissioner the board's authority to establish penalties under Ad Code Section 24-346B, which pertains to water conservation. On February 12, 2025, the amendment was published in the City Record. On March 20th, a public hearing was held. No comments were received from the public at the hearing or in writing. Today, the final rule, unchanged from the proposed rule, is before this board for approval.
Thank you, Frank. Just for the record, want to note that we're joined by Russ Pecunis from DEP.
Good morning.
Morning. Okay, are there any questions or comments on the final rule?
Is this the water penalty schedule being repealed from your rules?
That's correct.
Okay, so just in terms of where our rule is to replace it, we have final approval to publish it from the Law Department and Operations and to schedule the public hearing. But I have not gotten the go-ahead from our Commissioner's office to do that yet because there is a new first deputy mayor and they want to check and make sure if the procedures are the same. And so I haven't gotten permission to actually schedule the public hearing yet.
Okay.
But we do have the preliminary certification to go ahead and publish. So
So,
it should be any day now.
but that would be publishing in advance of a notice and comment.
We
packet,
haven't,
which you
yeah,
have a-
this would be to have the public hearing and then go ahead and finalize after the public hearing.
And the minimum time between now and then to finalize would be 60 days at best.
We would have to do 30 days before the public hearing and then 30 days after the final certification.
Right.
So at least 60 days.
Okay. From a timing standpoint, because our rule is supposed to go into effect, I believe simultaneously with the DEP rules, how should we, how should we proceed?
That would not be concerned because Section 2 of the proposed rule indicates that this rule takes effect on the same date as a rule promulgated by the Department of Environmental Protection. So no matter when they publish a rule, it'll coincide with the effective date.
Okay, good. So we're not running into a situation where if we repeal that there's a gap.
Correct.
Okay. Any other comments or questions on this rule? I know we had a hearty discussion before. Okay, I'd like to ask for a motion to vote and a second to vote on the adoption of the rule. Have a motion? Have a motion, a second? Second, okay.
Okay.
Proceed to a vote?
Commissioner Austin Rahman,
Yes.
Shamanda Graham,
Yes.
Jose Marquez on behalf of Joseph Gregory,
Yes.
Elizabeth Nauer,
Yes.
Madeline Legori,
Yes.
Russell Bakuni,
Yes.
Arminder Paul Rana,
Yes.
Matthew Schneid,
No.
Matthew Smith,
Yes.
Douglas Swan,
No.
Lisa Urban,
No.
Jared Whittington.
Yes.
Okay. We have 3 noes and 9 yeses. So the motion passes.
Okay, thank you very much, everyone. We'll now turn it over to Russell Pacunas from DEP to introduce 2 requests for cease and desist orders.
All right, thank you very much. So for this meeting, we do have 2 requests. I'll do the noise-related one first. So this pertains to AP Tenants Corp. The premises is 134 Atlantic Avenue in Brooklyn. This situation is actually a referral from council member Lincoln Ressler's office, who called us about this situation because of a large number of complaints from his constituents, and who then mentioned it again when he chaired the budget meeting recently for our department. This is a HVAC unit, a cooling tower on the roof of the building, which I provided a photo of at the end of the package. There is a medical office on the ground floor, then 3 floors of residential above it, and then the cooling tower in question is on the roof. This cooling tower apparently is only used seasonally. It is only used from about May to about September, October. And so although we have had many complaints about it in the past, we have only succeeded in issuing it 1 violation a year. We issued them a violation in August of 2023. And then we issued them another violation in on October 1st of 2024. The concern that we have and that the council member's office expressed is that this is going to be starting up again soon when the weather gets warmer. They only use it for 3 or 4 months while the weather is warm. And so normally we would wait in a situation like this to issue a 3rd violation before we came to the board to ask for a cease and desist order. But in this situation, we're asking for a cease and desist order now, even though there hasn't been there have been only 2 summonses, and the last one wasn't, since last October, because if we wait to issue a 3rd one when it starts up again this summer, then we would not be able to bring the cease and desist request to the board probably until the August meeting. And the cease and desist order would then get issued and they would be called in for a hearing after they stopped using it again for this year. And they would go through this whole cooling season using the unit in its current noisy condition. So we were asked if we could bring this to the board now to get a cease and desist order issued and a hearing scheduled before they start using it again, so that they're required to do something to either fix it if the noise is because it's broken, or do whatever else is required to abate the noise situation for this summer.
Questions? Yes, Beth?
You talk about the two prior violations. It looks like the obligation was to pay a fine, which they did. Is that right? Or they had to actually do work?
Anytime you are found in violation of the air code or the noise code, the judge's order incorporates a compliance requirement that's in the penalty schedule. So they would have been required as a result of each of these violations to comply.
One more question. I understand the concern about the summer and the violations, but don't we typically usually have a lot more than 2 violations before we issue a cease and desist order?
Usually, as I said, usually we have at least 1 adjudicated and at least 3 issued. But again, because of the seasonal nature of the use of this equipment, the past 2 years, we've only been able to get them in violation once each year. And again, the apprehension on the part of the complainants and the council member is that they've done nothing to fix this, and that when it starts up again, it's going to be noisy again all summer, and we won't be able to get them a violation and then a cease and desist order until sometime in August, by which time it'll be too late to require them to do anything about it for this summer.
Elizabeth?
If they come to the cease and desist hearing and they show that they've, they have like a report showing that they've done something to fix the noise,
Right.
then there wouldn't be, the equipment wouldn't be sealed and they wouldn't be charged with a violation.
Right, and you guys would then get a pre-sealing
Right.
report from the ALJ and that like you usually do when cease and desists are resolved.
Is there some sort of rule that sets the 3 violation precedent, or is that just kind of?
Tradition. It's tradition. The hearing officer who used to sort of be in charge of cease and desist orders many years ago, Phyllis Roberts, sort of established a precedent that we should have at least 3 summonses issued before we asked for a cease and desist order. And in the absence of unusual circumstances, we have sort of continued to adhere to that.
Other comments?
Another question.
Yeah, sure.
Is there anything that's preventing the DEP from issuing more than 1 ticket a year? Because I mean, I think.
No, except that we only have so many inspectors and they only use it for a few months a year, and we have to catch them using it, and the readings have to be, so it not necessarily, but it's just worked out that way. Yep.
Does your agency practice in cases like this to wait for the hearing adjudication? Because I think that would play a role. Wow.
Well, before, in other words, before we
Yeah,
could
sure.
ask for a cease and desist?
No, before you issue another sum. I'm thinking about the fact that they only operate a certain time of year. So even if you issue 1, by the time you wait for the hearing, the season is probably over. So no matter what you do, you might only be able.
Well,
to
yeah,
issue
I mean,
one.
that's true. And especially since the one last year wasn't issued until October 1st. The hearing didn't come up until after they had stopped using it
Okay.
for the season.
Question.
So if they're not using it right now.
No.
Right? So how would a cease and desist order work under the circumstances? Because we're telling them not to use it, but they're not actually not going to use it.
Presumably they'd have to bring somebody in. I mean, I don't know if they know why it's noisy or not. If it may be broken, it may need to be serviced or whatever, I don't know. But they presumably would have to bring a contractor in and turn it on and take readings and figure out why it's been noisy. Also, if cease and desist order is approved today and the hearing is scheduled maybe a month from now, then at that point, we are into May, and they're probably getting close to when they're gonna start using it anyway. So,
So, I mean, I'm just thinking in terms of how those types of systems normally work, and I'm not an engineer, just from general knowledge. It's usually turned on at a certain point, but it can't be turned on until, or it's not typically turned on until the point where it's going to be used.
Yeah, they
So,
drain, right, they drain.
right, yeah, they drain them. So just from a standpoint of functionality, if we issue the cease and desist order today, how long would they have for compliance purposes? in
that
order
would be
to
up to the hearing officer,
Okay, and the hearing would be around,
probably in around a month.
okay,
But I think, Lisa, part of, if I understood your initial question was, a cease and desist is you're doing something,
right.
please stop it. And right now they're not doing it. And so it's like,
No, I-
we issue them on something where we anticipate, we expect
Right.
it's gonna happen, but we don't know. And for all we know,
Right.
it
And
could
then
be
again,
turned on,
the
it could be
circumstances are a little unusual, but
Yeah.
if we didn't ask for it at this meeting,
right.
then effectively they're getting to use it as is for another year.
So I'd like to just explore a few scenarios here. Our next meeting would be in June. I understand the timing issues you raise if we don't do it now and we wait for another summons and another summons adjudication and then a cease and desist. By then the season is over. But what if at the next meeting, DEP came and presented evidence like the affidavits that are here, where it's not a summons, but it's a note from an inspector saying the season has started. I can affirm that we took a reading and it's this amount. Then could the board proceed with the cease and desist order at that time? It would be without a third summons, but at least would be with some evidence that if this season has started and in 2025.
Well, if they started using it and we went again and took readings and they were high, they're gonna get another summons. It's not just gonna be a matter of we're gonna report to the board that they were
Yeah.
that they were high, we would issue another summons.
But what I'm suggesting is that in that instance, we wouldn't need to wait for that summons to be adjudicated. The season-
No, I mean, normally we don't wait for all three of
Yeah.
the summonses to be adjudicated.
Yeah,
Normally, one or two of them are still open
right.
at the time that we ask for the cease and desist order, because sometimes summonses can take a long time to get adjudicated.
That's right.
If people ask for a reschedule, that reschedule date could be in 6 months.
True.
So, no, we don't wait for all of them to be
I
adjudicated.
see. Elizabeth?
Yeah, I was just gonna make that point. I remember a few examples where there had been two that were adjudicated or defaulted and one that was still, waiting for the hearing where we'd issued cease and desist orders. So I don't think, I think what the timing issue still remains though, because if we issue a cease and desist order in June, then that hearing wouldn't be until
July.
July, and it does seem to present the likelihood that they'll be operating the system and still in the noisy condition, given that at the past hearings, they showed no, reading the hearing decisions, it suggests that they showed no intent of doing anything to come into compliance, but I'll just put that out there.
Lisa?
But how do you issue a cease and desist order for something that they're not doing?
Well, you are telling them to desist from engaging in that activity. It's not just ceasing, it's desisting as well. And we're telling them you can't use this.
Do we know if they haven't done anything? How do we know they're still going to be in violation once they start the equipment? Do we know now that we're in 2025? Do you know if?
Well, the only
They've done
evidence we
anything?
have on that is that they didn't fix it in response to the violation we issued in 2023, because they had another one last year. So I don't know, and if you look at what happened at the hearings, they basically had a rep appear and say no contest. So they did not put forward any evidence at either of the hearings on the summonses that they were doing anything. They just say, we're not admitting this, but we're not really denying it either. And so we have no evidence really, except that they didn't fix it in response to the 23 summons.
All right, go ahead, Doug.
I know you said the tradition is 3 summonses, right? So do we have any other instances where there's some special circumstance where it's less than 3 summonses where we did something like this?
Yeah, well, all of the ones that we recently requested for people who are still using number 4 fuel oil, many of them were based on 2 summonses.
Mhm.
I just also wanted to make another point about timing, that if the sooner this gets towards a resolution, the less likely the residents will be in the really hot part of the summer with and a sealed condition on the equipment. So, you know, I guess there's more chance that it gets resolved before it gets really hot and less chance of sealing when it's in August, but
And so that's advocating towards doing something sooner than later.
yes.
Is
If we issue a cease and desist now, aren't we effectively saying cease and desist the activity that was presented in the first 2 summonses? So we're not necessarily saying stop doing what you're doing right now. We're basing this on the predicate summonses, which means stop doing what you did that caused the issuance of those summonses. That being the case, the special hearing, isn't it designed to give them the opportunity to say, hey, here's what we've done to correct this?
Yes.
That
Yes.
being so, I don't see a reason why we wouldn't compel that quickly before the season starts, especially because that hearing could happen either right at the beginning of the season or before the season. And then at that point, we would know whether they're going to comply, and we would see a 3rd summons at some point anyway, if they don't.
Lisa,
Or the,
then Matt?
or the sale.
No, I was actually thinking the opposite of that, but your argument actually makes sense. So I have no further comment on it.
How does it looks like there's a fine that goes along with the cease and desist, is that right?
I'm sorry?
Is there a fine that goes along with the cease and
Yeah.
desist?
Yeah, they were fined $440 for each one.
No,
going
no,
forward, if there's a
if we
cease
do
and
cease
desist.
Oh, well, that is, the hearing officer who does the cease and desist hearing can theoretically recommend that an additional fine be imposed as part of their recommendations to the board. But if they have come into compliance, I've never seen the hearing officer recommend an additional.
On the letter you have here,
Yeah.
it said 875 and
Yeah.
for 2 days. That's what they would get if they are not in
Right,
compliance. with
which
the
is,
hearing.
and that is the hearing officer who holds the hearing on the cease and desist order can recommend that that additional fine be imposed when they make their recommendation to the board. But as I said, if they do the work, whatever it is that's required to come into compliance, and that's the recommendation that's coming to the board from the hearing officer, I've never seen the hearing officer recommend an additional penalty.
So just follow up, if we issue the cease and desist today, they would then have to make whatever repairs or changes to the equipment.
Right.
And then present that to the hearing officer in
Correct.
order for them to be able to use the equipment.
Correct. And the hearing officer has the ability to adjourn it, to give them time if they need to order parts or get a buildings department permit or whatever it
But
is.
they can't use it in its current condition.
No, they can
now.
continue to use it.
Even
The
with
judge
these-
can allow them to
Okay.
continue to use it.
But between that, when we issue the cease and desist and they have the actual hearing, they can't use the equipment.
No, they can only not use it if we seal it. And we can only seal it if they don't show up for the hearing
Okay.
or if the hearing officer tells us.
Yeah, the hearing's like in order to show cause,
Right.
meaning that it's not pre-hearing deprivation. It's
Okay.
only after.
And if they do show up for the hearing, it'll come back to us to approve the sealing.
Okay.
Right, that way, this way, if we get a hearing scheduled in May, then we will know by May whether they show up. And if we don't show up, then we can go and seal. And if they do show up, then they will inform the judge what they're doing.
And it's not a defense to our issuing the cease and desist order that it wasn't being used at the time that we issued the cease and desist order.
That's for the judge to determine.
Okay.
One last point I would bring up, because we've been talking about the timing of all this. If the cooling tower, if it's not just an issue of the cooling tower needing a repair, it's actually just loud because of its location. The actual remediation of that could take a long time.
Depends on what they have to do.
They need to build a noise barrier wall or something like that. It could take months. So,
They'd have to get a permit and
Yeah.
everything.
Yeah. Shimon?
I have one other point. If we don't do something, at least from my perspective, it is very possible that the cost of the summonses is just simply not a deterrent.
Right.
Because of the cost of the repairs.
Yeah.
So it's almost as if you can issue as many summonses as you want until we pass this motion. We're going to hear, well, the neighborhood will hear the noise.
And to Jared's point, even if we waited this year, then it could all sort of like happen next year again too, that they're still in the process of getting a permit if to build an enclosure or whatever, so.
Other comments? All right, let's advance this forward. Can I have a motion to vote on the cease and desist order for 134 Atlantic Avenue? See a motion, I see a second. Hey, this is,
Are there any objections to the motion approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
thank you,
All
everyone.
right, thank you, and we will let the council member know as well. On the second one, this is for Meta Hot 3 Inc. At the 18 West 38th Street in Manhattan. This is a restaurant. And we did an inspection there in July of 2023 that resulted in a commissioner's order being issued. And if you look at the second page of the request in item 1, it goes through a extensive list of grease traps that they were ordered to install, both on the main level, I guess, and in the basement. And the order required them to comply within 60 days by September of 2023. In October of 2023, we did a follow-up inspection and observed that they had not reinstalled any of the specified grease traps. And they therefore were issued a summons. And during that same inspection, the inspector observed that there was hardened grease in one of their already existing grease traps, indicating that it had not been properly cleaned. So they received a summons for that as well. In December, another summons was issued for not complying with the original commissioner's order to install. And also, due to another observation of hardened grease in an existing grease trap, they were issued another summons. Then in July of 2024, after an inspection showed that water flow in the establishment was being affected, a new commissioner's order was issued requiring them to snake out the existing plumbing lines connected to one of the grease traps, to snake out the connections to all of the floor drains. Then in September, as they had not complied with either the original commissioner's order or the second one directing them to snake out the connections, they were given another summons. In October of 2024, they were given another summons for not complying with either of the orders. They were also served with a notice to attend a mandatory compliance meeting scheduled for February 19th of this year. They have not appeared at any of the hearings on any of the summonses or for the compliance meeting. And based on the continuing failure to comply with either of the commissioner's orders and their failure to appear for the compliance meeting, DEP is asking that the board issue an order to cease and desist.
Okay, thank you, Russ. Any questions? Okay, can I have a motion to approve? I see a motion, a second. Second? Okay.
Are there any objections to the motion approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Okay, thank
All
you,
right,
Russ.
thank you.
All right, may I have a motion and a second to go into executive session? A motion and a second.
Any objections to the motion to go into executive session? Seeing none, hearing none, the motion is approved unanimously.
Okay. Okay, we can return to public session. Okay, we are back in public session. Are there any other questions or business from any members of the board? All right, I'd like to look at possible dates for our next meeting. That would be in June. I'd like to propose June 12th or the 26th. The 5th I'm not available and the 19th is a public holiday. Any concerns with either the 5th, either the 12th or the 26th? Yes, you want.
I don't personally have concerns, but I know the 26th is around graduation time for
Okay.
a lot of folks, so just.
Yeah, that's a fair point.
Yeah.
We also have our remote session.
Panel?
On the 20, yeah, panel.
On the 26th?
If we need to.
Okay, fine. But how about the 12th? Is the 12th an available date for
Okay.
folks? I'll take a better date.
Good.
Yes.
Any, see a lot of head nods. Okay, all right, so we will go with June 12th. All right, before we close, just a reminder to everyone to please sign the attendance sheet. And I'd like to ask for a motion to adjourn. In a second.
Are there any objections to the motion to adjourn the meetings? Seeing none, hearing none, the motion is approved unanimously.
Okay, meeting's adjourned. See you all in June. Thanks very much, everyone.
Enjoy.